Welcome to Lesson 3, Part 3, Subpart 4, which is entitled Rights and Safeguards for an Accused Person. This part of Lesson 3 has been combined with Week 10 and Week 11 lessons entitled Constitutional Safeguards to Ensure Fair Trial of an Accused Person, Part 1, and Constitutional Safeguards to Ensure Fair Trial of an Accused Person, Part 2, respectively. Because of the monotony of treating the same subject thrice when covering all aspects at once makes it easier to grasp the dimensions of the topic. According to the United Nations, human rights are rights inherent to all human beings, regardless of race, sex, nationality, ethnicity, language, religion, or any other status. Human rights include the right to life and liberty, freedom from slavery and torture, freedom of opinion and expression, the right to work and education, and many more. Everyone is entitled to these rights without discrimination. Closely related to human rights is international human rights law, which lays down the obligations of governments to act in certain ways or refrain from certain acts in order to promote and protect human rights and fundamental freedoms of individuals or groups. One of the achievements of the United Nations is the creation of a comprehensive body of human rights law, a universally and internationally protected code to which all nations can subscribe and all peoples aspire. The United Nations has defined a broad range of internationally accepted rights, including civil, cultural, economic, political, and social rights. It has also established mechanisms to promote and protect these rights and to assist states in carrying out their responsibilities. The foundations of this body of law are 1. The Charter of the United Nations, and 2. The Universal Declaration of Human Rights adopted by the General Assembly in 1945 and 1948, respectively. Since then, the United Nations has gradually expanded human rights law to encompass specific standards for women, children, persons with disabilities, minorities, and other vulnerable groups who now possess rights that protect them from discrimination that had long been common in many societies. The International Covenant on Civil and Political Rights that was adopted and opened for signature, ratification, and accession by the General Assembly Resolution 2200A 21 of 16 December 1966 and entered into force on the 23rd of March 1976 in accordance with Article 49 is an attempt to further expand the foundations of international human rights law. The Universal Declaration of Human Rights (UDHR) is a milestone document in the history of human rights. Drafted by representatives with different legal and cultural backgrounds from all regions of the world, the declaration was proclaimed by the United Nations General Assembly in Paris on 10th December 1948 by General Assembly Resolution 217.A3 as a common standard of achievement for all peoples and all nations. It set out, for the first time, fundamental human rights to be universally protected. Since its adoption in 1948, the UDHR has been translated into more than 500 languages and has inspired the constitutions of many newly independent states and many democracies. The UDHR, together with the International Covenant on Civil and Political Rights and its two optional protocols on the complaint procedure and on the death penalty, and the International Covenant on Economic, Social and Cultural Rights and its optional protocol, form the so-called International Bill of Human Rights. While Article 55 of the UN Charter encouraged member states to do everything within their power to guarantee universal respect for and observance of human rights and fundamental freedoms for all without distinction as to race, sex, language, and religion. The Universal Declaration of Human Rights plays a dual role. It goes into fine-grained detail to define what constitutes basic human rights on the one hand, and also serves as a barometer for measuring how human rights, friendly or unfriendly, a state is on the other hand. What is the correlation between the narration above and the rights and safeguards for an accused person under Nigerian criminal law? Well, in the year 1976, Nigeria became a signatory to the International Covenant on Civil and Political Rights. And in 1993, following ratification and accession, a state party. In 1978, the then military government promulgated the 1979 Constitution of the Federal Republic of Nigeria, which largely incorporated some basic human rights that the International Covenant on Civil and Political Rights and the Universal Declaration of Human Rights recommended states to pass into law in their respective domains. Subsequently, the 1979 Constitution of the Federal Republic of Nigeria was superseded by the 1999 Constitution of the Federal Republic of Nigeria, partly because of the reintroduction of a democratic government on the one hand, and to correct perceived anomalies with the former, which included anomalies relating to human rights law. Both the 1979 Constitution and the 1999 Constitution made provisions for fundamental and inalienable human rights. These rights ensure the fair and just prosecution of crimes. These rights also ensure that accused persons are treated properly, irrespective of the fact that they are suspected of being responsible for the commission of crimes. In summary, Nigerian criminal law has the following rights and safeguards for accused persons. 1. Constitutional or national jurisdictional provisions. 2. Procedural jurisdictional provisions. 3. Statutory provisions. 4. Provisions courtesy of case law. Let's consider these one after the other in subsequent videos.